Hi there and welcome to our probate channel. If you're an heir to an estate in California, you might have a lot of questions about the probate process, especially when it comes to real estate transactions. In today's video, we're going to answer some key questions every heir should ask when interviewing a real estate agent for a probate sale. Let's get started. First, a really important question: does the personal representative have full authority or limited authority under the Independent Administration of Estates Act? The IAEA is a series of laws that allow the personal representative to administer most aspects without court supervision. In California, personal representatives can be granted either full authority or limited authority to handle the estate. Full authority means you can sell property without needing court approval, while limited authority requires court confirmation for major transactions, including real estate sales. This distinction impacts how quickly a sale can happen. If the estate is large enough or there are complex issues, a judge might only grant limited authority. It would be wise to consult with an attorney who specializes in probate, as there might be ways to offset this limitation, or you'll need the expertise in the added rules and documents. Second, which court documents do you, whether full or limited authority, is granted? Good question. You'll find this information in the letters of administration when there is no wills, or the letters of testamentary when there is a will. These documents will clearly state what powers the personal representative holds. If you're unsure, ask for a copy of these letters. Third, now let's talk about paperwork. What forms are used in the sale of a probate real estate transaction? The most common forms are from the California Association of Realtors, or CAR. The key ones are the RLA-CA, Residential Listing Agreement, the PA, Probate Advisory, the PLA, Probate Listing Addendum, and the RCSD-S, Representative Capacity Signature Disclosure. These ensure that the sales comply with probate laws and provide clear terms for both buyer and seller. Fourth, when can personal representative sign your listing agreement? This is an important step. The personal representative can sign the listing agreement only after they've been officially appointed by the court and after receiving letters of administration. This could take a little time, so be patient as the process unfolds. Next question: what is the allowable commission rate for realtors in a probate transaction? In California, the commission is negotiable, but typically it ranges from 4 to 6% of the sale price. Just keep in mind, the commission is subject to court approval if the sale needs court confirmation. 6. What about the minimum sale price for a property sold in probate? The minimum sale price must be at least 90% of the appraised value set by the probate referee. This is a critical number because it helps ensure the sale is fair and equitable for all heirs. 7. When can you accept an offer in probate? You can accept an offer once the personal representative has full authority or after a court order is obtained in a limited authority case. However, if court confirmation is required, the offer must be presented for approval in court. At the close of escrow, the proceeds must be deposited into the estate's account. Number 9. What's the minimal deposit amount in a probate sale? Typically, the deposit is 10% of the offer price. This shows the buyer's commitment and ensures they follow through with the transaction. 10. How does the appraised value from the probate referee impact the sale price? The appraised value helps establish the minimum price for the sale, but the final selling price can be higher, especially in competitive markets. Just keep in mind the sale can't go below that appraised value unless special circumstances apply. Number 11. When is court confirmation necessary? Court confirmation is required when the personal representative has a limited authority or if the sale price is lower than expected. If the sale under full authority, court approval isn't needed, but it's always essential to check with the probate attorney to be sure. Number 12. Here's an interesting question. When is the overbidding process used, and can you walk your buyer through this process? Let's say you have an accepted offer of $500,000, but the sale requires court confirmation. In court, other buyers can overbid on the property. The overbid process starts at 10% above the accepted offer plus $500. So the starting overbid would be $550,500. This ensures that the estate gets the best possible value. Once the initial bid is established, here's how overbidding works. In order to participate in the probate auction, you need to bring proof of identity, driver's license or passport, cashier's check for the required deposit, often 10% of the opening bid. For example, if the property has an opening bid of $500,000, you may need to bring a cashier's check of $50,000. Additional documentation. Some auctions may require you to fill out forms or provide additional documents. For example, proof of funds before you can bid. Make sure your cashier's check is made out to the Orange County Superior Court or the designated entity handling the sale, usually the probate referee or trustee. Overbidding. You can increase the amount in increments of at least $1,000. Winning bid. If you make the highest bid, you win the auction. The state will receive the overbid account and you will be required to submit a cashier's check for the deposit. After the auction, court approval. Auction results in subject to court confirmation. This usually occurs subsequent hearing where the judge will review the bids. If there is an overbid, the judge will confirm the highest bid and approve the sale. Full payment. Once the judge confirms the sale, the winning bidder must provide the remaining balance of the purchase price minus the deposit, usually within 10 to 15 days after the court confirmation hearing. The payment must be made in the form of a cashier's check or a wire transfer to the state or the designated representative. Transfer a title. Once the full payment is received and all conditions met, the court will issue an order confirming the sale and transfer the title to the buyer, closing the sale. After the sale is confirmed by the court and the full payment is made, the administrator or executor of the estate will handle the closing. The deed will be recorded with the Orange County clerk to transfer ownership to the buyer. If you win the auction, you will receive a grant deed, which officially transfers ownership of the property to you. Key things to keep in mind. 1. No contingencies. Probate sales are typically as is. Sales with no contingencies, meaning you buy the property in its current condition and you generally cannot request repairs or other concession. 2. No inspection. Buyers usually cannot inspect the property before the auction. You're purchasing based on the information available. 3. Final sale. Once the sale is confirmed by the court and the funds are paid, the transaction is final. There's no cooling off period or right to back out. Number 13. What legal documents does the title company need before escrow can close? The title company will need the order for probate sale, court confirmation order, letters of administration, and possibly the notice of proposed action. Make sure your attorney and title company are aligned in this paperwork. Number 14, speaking of this, the document is crucial because it informs all heirs and interested party what the personal representative plans to do. This notice allows everyone to raise concerns or objections before anything is finalized. Finally, when can escrow close in a probate transaction? The timeline can vary, but it usually takes at least 30 to 45 days after court confirmation. If the sale is straightforward and doesn't require court approval, it might be quicker. Just make sure to communicate with your attorney and real estate team throughout the process. So even though the sale of the property may be done within the first couple of months, it will not speed up the probate process. It will save you in carrying costs and the possibility of whole house system failures that need to be repaired. That covers the essential questions every California heir should ask when navigating a probate real estate sale. If you found this video helpful, be sure to subscribe and share with others who might benefit. And always don't hesitate to reach out to a probate expert or real estate attorney if you have questions specific to your situation. Thanks for watching and good luck with your probate journey.